Good evening, everyone. We're here to just wait a couple more minutes to see who else will join us. To preface this presentation, we'd like to just say that closed captioning is available in different languages for participants that wish to use the function. And to do so, please follow the instructions on the screen, and we'll have our interpreters also share these instructions in said languages.
大家好，歡迎參加今日嘅網上會議。我哋今日會提供翻譯服務，係包括廣東話同埋西班牙語。想聽到翻譯嘅朋友啦，一陣間我哋啟動翻譯功能嘅時候啦，你會喺屏幕嘅下方見到一個地球儀嘅標誌，寫住 Interpretation 口譯，跟住撳入去選擇語言。咁想聽廣東話咧，就係 Chinese 中文就會聽到噶啦。如果你用手機入嚟嘅話咧，請喺屏幕嘅手機上面咧揾嗰3個點，跟住撳一撳。然後選擇 Interpretation 口譯呢個功能，跟住再點入去選擇語言就係 Chinese 中文，你會聽到廣東話翻譯。如果你淨係想聽到翻譯講嘢，唔想聽到講者原音嘅英文嘅話咧，你可以撳關閉原始音訊嘅呢個按鈕，咁就可以聽到翻譯嘅講話啦。多謝 ，Thank you。
Muy buenas noches a mis hispanoparlantes, aquí su intérprete en simultáneo para esta velada. Mi nombre es Martín y les voy a estar sirviendo como su intérprete en el canal de interpretación en español. Por supuesto que para accederlo lo único que tienen que hacer es hacer clic en el botón con forma de planeta que se encuentra en la parte inferior de sus pantallas. Al hacer eso, eligen español o Spanish y allí me encontrarán a mí durante toda la sesión en simultáneo. Muchísimas gracias, que disfruten su sesión y su velada. Thank you.
Thank you both for that. We'll continue on to the next slide, which will provide a couple more instructions in closed captioning, and that will allow us to formally proceed on with the presentation. Here we have the final instructions to access closed captioning. If anyone does have any issues accessing this, please inform us through the chat and messaging options available here. If there are no issues, I will then proceed having us go forward with the presentation. All right. Well, good evening, everyone. I am Aristos Kamiji, and I act as Director of Asset Building Programs and Housing Rights Counsel at Mission Economic Development Agency, MEDA for short. Today, we will be sharing a little bit about our organization and partnership with Homeownership SF in anticipation of the SF Housing Expo on Saturday that we are all looking forward to. Before we begin, to share some information on tenant-landlord rights and responsibilities, I would like to state that nothing in this presentation is intended to serve as legal advice. This workshop is being recorded for Homeownership SF's YouTube channel. We ask that you please hold questions until after the presentation, as we will have a Q&A period that follows this presentation. When it comes to MEDA's relationship with Homeownership SF, I think the best way to describe it is that we are part of a shared community to address housing issues in the city of San Francisco. While we all have distinct approaches to how we render housing services, we partner together to coordinate our efforts in order to further our impact. In that sense, Homeownership SF often functions as an organizer of this coalition of housing agencies in order to set up workshops, networking events, and forums for MEDA and others to host events for the community. Let's continue to the next slide, please. Thank you. While our organization wears many hats Our foundation at Meta begins with the direct services that we have provided to the local Spanish-speaking Latino community here in San Francisco since 1973. Last October, we were lucky enough to celebrate our 50th anniversary. And when it comes to housing, we support our clients with services across the home ownership spectrum. And so that includes everything from acquiring a BMR rental unit to foreclosure prevention. It is along this Thank you. It is along this spectrum that Meta brought me in to establish our eviction defense and housing stabilization program that is purposefully designed to support our monolingual Spanish-speaking community when facing displacement threats. Additionally, we provide financial coaching and employment assistance as part of our vision to advance Latino wealth building in San Francisco. If anyone has more questions about what we do at Meta, please feel free to reach out directly to me after this presentation. And now I'll leave the floor to Maria for her to continue. Thank you.
Thank you, Aristos. I am Maria Zerbel. I'm a staff attorney at Apilo, Asian Pacific Islander Legal Outreach, and I'm delighted to be with you tonight in order to do just a very brief summary and overview of tenant rights, tenant landlord law in San Francisco, and sort of the associated issues that come with that. So San Francisco, a handful of years ago, voted to become one of the first cities that guarantees legal assistance to any renter who is facing eviction. And the Eviction Defense Collaborative, as you see on your screen, is the principal organization, the lead partner for a project called Tenant Right to Counsel. And that is that anybody, like I mentioned, who's facing an eviction does have a right to seek assistance. And so the EDC, along with their partner legal aid organizations, of which Apilo is one, we have partnered to implement this project for the last 4 or 5 years. And are having great success in helping people to avoid homelessness, stay in their homes, and otherwise defend themselves against harassment, discrimination, some of the things that go on in our market here. So the Eviction Defense Collaborative, EDC, as it knows, is the principal organization in San Francisco that helps tenants respond. And they have legal assistance for people who come in who are facing an eviction. They also have a rental assistance program to help folks who need help with back rent or future rent, and a shelter advocacy program. Now, all of the agencies that work with EDC can tap into the rental assistance. I'll speak a little bit more on that later, but basically that aspect of rental assistance helps San Franciscans who have fallen behind on their rent and due to a financial setback, and they can apply for both back rent, for rent going forward, move-in costs. They have a range of programs depending on the status of your situation. And so that is the collaborative, the Tenant Right to Counsel Collaborative. As I mentioned, there are a group of agencies who all work together, EDC being the main clearinghouse, and then they refer folks who come in who have eviction issues to the group that you see here. The AIGS Legal Referral Panel is one, API Legal Outreach, which is where I work, Bay Area Legal Aid, EDC themselves provides representation for those facing homelessness or an eviction action. HAP, the Homeless Advocacy Project at the Justice and Diversity Center, Legal Assistance for the Elderly, Open Door Legal, and the Tenderloin Housing Clinic. We all work in this collaborative to defend those who are facing eviction. So let's just start out by talking who is a tenant, because this is actually a well misunderstood concept in SF. Anyone who has an established residency with or without a lease has a right to occupy the unit. That person is a tenant. That means that you can shake the hand of somebody, get the keys, agree to pay them a certain amount of rent, move in and you are a tenant. Now, the problem with an oral agreement like that is it's hard to then prove if there's a dispute in the future what the agreement terms were. But that person is a tenant. Anyone who has a oral or written lease, has established residency, has a right to occupy that unit, and you are a tenant. So we have a lot of shared housing in San Francisco as well. Subtenants do have rights as tenants, but they are more limited depending on the situation. If you live with your master tenant and share parts of the units, there are some distinctions there. Master tenants also, if they are subleasing or other people are subleasing from them, do have rights as tenants as well, because they are tenants according to the lease, but they also may have responsibilities as a landlord. And so you need to be clear about that when you're coming up with these different arrangements, that you're clear about what's going on. So landlords, we hear from landlord attorneys all the time how difficult it is to be a landlord in San Francisco. There are very strict regulations that landlords need to abide by in order to be able to legally rent their homes and apartments and other places, ADUs, all sorts of different residences that qualify for rental in San Francisco. Now, the balance of that is the law, those of us who work on the tenant side, the law seems to favor a little bit the landlords. They're the ones with the power, there's the ones with the property. And so as a balance to that, the courts require landlords to very, very strictly comply with the regulations that are out there, so that they have to do very clear procedural guidelines and very clear substantive guidelines. They have to follow the substance and the procedure very exactly to pursue an eviction in San Francisco. So for example, a landlord must give 24-hour written notice before they can come into a room or a unit that they're renting to you, except for an emergency. Obviously, if the bathtub is overflowing and water is going everywhere, they get to come in. But otherwise, they have to give you 24-hour written notice. They can't just demand to enter at any time. They have to give you a copy of your lease if you request it in writing. So even if your lease was oral to begin with, if you request one in writing, they have to give you a copy of that lease. And one of the biggest issues we find, not just in San Francisco, but in the whole Bay Area, is that they have to give you what's called a habitable home. There have to be minimum acceptable living conditions in this unit, and they have to make necessary repairs. They do not owe you, as a renter, the best possible unit that's available. However, there are certain minimum standards that are required, and you can see them listed here. There has to be code specific plumbing, gas, electric, sewage, heating systems. There has to be weatherproofing. I had one client who said it rains inside when it rains outside. That is not a habitable unit. There has to be hot and cold water. There have to be places to throw away your trash. There can't be holes in the flooring. There can't be missing steps. And you have to have private access to a locked mailbox. These are the minimum things that are required that a landlord provide for your rental unit. There's, of course, things landlords cannot do. They cannot lock you out of your home. If you miss the rent 1 month, 2 months, 3 months, any point, they cannot lock you out of your home. There is a very specific procedure that has to be gone through, and this is called constructive eviction, or there's many other terms for it, but that's not the way that they can evict you from your home. They cannot evict you or raise your rent without written notice. If you get a text or an email from a landlord saying your rent's going up next month, that is not legal. And so they must give you written notice, usually with a certain amount of time, depending on your situation, before that rent increase goes into effect. They cannot charge punitive late fees. Late fees are allowed, but they can't be to the point of, astronomical or punitive. And they cannot require you to pay rent in cash. They cannot require you to pay it online if they have a portal. There is no such thing as a verbal eviction or a verbal rent increase. There are very strict codes for what has to be done, what has to be said, what has to be written, and the timeline in which that happens. So these are things that your landlord cannot do. So one of the big things that we see a lot of is units that are not considered habitable. And habitability is one of the biggest defenses when it comes to evictions, that the unit is not maintained to the required minimum standards. Now, we always tell folks, do not just stop paying rent. That is not the way to solve a problem with habitability. There are ways eventually that can happen, but there are much better processes to help get that issue resolved than stopping paying rent. So definitely you want to send a letter to your landlord in writing with proof of mailing. Written notice is required for these sorts of habitability issues. We have lots of folks coming saying, yeah, I told my landlord this was happening. They can always decide that they didn't hear it, that they didn't remember it, that the things get lost in communication. You need to have written notification to your landlord and proof that you mailed it to them. One of the other big things in San Francisco is you can make a complaint to the DBI, we call it the Department of Building Inspection, Housing Inspection Services. The number there is on your screen. They will come out and inspect the building to make sure that it's up to code, that there's no violation of code. And they can force the homeowner to make changes, improvements, repairs that are required to bring it up to code. There can be processes there where your rent is abated if they do not make those changes, but you need to go through the DBI, the Department of Building Inspection. The other big option is the rent board. They deal with these things all the time. It does not require a lawyer. You can go and fill out a petition applying for things to be fixed, for your rent to be adjusted. They take these complaints very seriously, and it's a great way to try to get some help in addressing issues maybe that you're struggling with in your unit. So those are some ways that you can get repairs when you need. Now, we know that San Francisco has rent control. It is not a blanket universal, everybody's under rent control. There are restrictions to this, and this is city specific. Most of the cities outside of SF also have rent control, but you have to know what county you're in and what city you're in. So these limits to rent control generally do not apply to newer buildings. This is a rolling date, but properties built after June of 1979 are not under rent control. Newer units do not have limitations in the ordinance. Condominiums, single-family homes, and government-owned or subsidized units. So if you are a voucher holder or the unit has a voucher, these things are not subject to rent control. A single-family home, however, with an in-law unit is covered. The key distinctions here that you have to be aware of is, are you sharing living space with the owner, with the landlord, with the master tenant? These are key things. Do you share a bathroom? Do you share a kitchen? Is it a separate independent unit? And so a single-family home that has a separate ADU, those ADUs, in-law units, whatever you want to call them, are covered because they are separate and they don't share facilities. But there are some places that are not. If you're in public housing, if you're a Section 8 or a voucher holder, the unit can have a voucher that is attached to it. Those are also under different sorts of regulations, usually more restrictive. So not every single unit, not every single home, not every single property in San Francisco is covered by rent control. Of course, one of the great things that rent control does and our SF ordinance does is it stops excessive rent increases and stabilizes housing. This is why over time, your unit becomes more and more valuable. The rent that can be charged for that unit to you only can go up by a certain amount. But it also puts pressures on landlords who sometimes then put pressure on tenants to move out, because as soon as somebody moves out, they can set the rate all over again to a market rate. The longer you're there, the more a landlord may feel that they want you out because they can raise the rent. But the rent increases are capped as long as you stay in your unit. Every year, the agency puts out, the city puts out the amount that rent can be raised for the coming year. You can see here the last 3 years, it varies quite a bit. This past year, they were only allowed to raise rates 1.7%. And so this keeps housing affordable as long as you stay in your unit. Of course, the minute you move, you may lose that protection. It starts again if you're in an eligible unit, if you move into another place. But again, you have to stay in the unit, and as long as there is a original occupant of that unit, the amount that the rent can be raised is very limited. Also, you can see here what this ordinance does is you must have what's called just cause to evict. A landlord can't just decide one day that they want you out. There has to be a good reason for you to be evicted. There are 16 different reasons listed in the San Francisco Code about how this can happen. And these things provide protection so that renters are not just put on the street without any reason and without any recourse. So going back to our tenants' rights to counsel, this is the No Eviction Without Representation Act. This came about through Proposition F, approved by the voters in June of 2018. We're one of the few cities in the country still that has these protections. It was approved in June of 2018 with services starting about a year later. So what this proposition said is that tenants who have received an eviction notice or have been served with an eviction lawsuit, and they're not living with their landlord, that's one of the exempt groups, they have a right to a free attorney. Just like in criminal cases, you have a right to an attorney. If you are a tenant and you've received a notice or a lawsuit for eviction, you have a right to an attorney. Now, not every tenant is eligible for what's called full scope representation, but all tenants are eligible for some sort of legal assistance. There is what's called limited scope and what's called full scope. There are not enough attorneys who do what I do out there to help all the renters, but we can at least help you answer the complaint, give some advice, and help you negotiate with your landlord to come up with a solution. And most tenants who find themselves in this situation do end up with full scope representation, which means if that negotiation is not successful with the landlord to resolve your issue, they will be able to support you all the way through a trial if that's what it takes. So as noted previously, there are 16 just causes, basically good reasons to be that the landlord has to have in order to evict you. I've listed the 5 most common ones here. Non-payment or not paying your rent is the biggest one. You can be evicted if you don't pay your rent. If you violate your lease. If you are what's technically called nuisance, that is, you're doing something that is a threat to yourself or others. Perhaps you are threatening your neighbors. You are violating your lease in other ways. You're raising pit bulls in the backyard. You're doing things that your lease prohibits. You can be subject to an eviction for these actions. 2 others of these, which are fairly common, is an owner move-in when the house is purchased by a new owner who wants to actually live in that house with their family. That is also considered a just cause, a good reason to be evicted. And then the Ellis Act, which was pushed through by landlords who want to get out of the business of being a landlord. They are allowed to evict tenants with the assumption that that unit or that property or the entire building is taken off the market. They're not allowed to rent it for typically 5 years after it's removed from the market. And that is another reason they are allowed to get out of the business of being landlords. Now, this that was passed, this Proposition F that was passed half a dozen years ago, has had amendments, which is what's in the black box here. You have some things that you can do. Sometimes, like if you're being sued for eviction because you haven't paid the rent, they have to give you a chance to pay the rent, right? You have to have a chance to cure offenses. You have to, so then there's some other things here that what the landlords have to do, right? They have to show proof, give some sort of statement about what you are doing and why that's cause for eviction. It used to be that a landlord could evict you if you brought in a roommate. They cannot refuse to allow you to bring in a roommate as long as you're not exceeding a maximum capacity. And so if they have a good reason and they can make their case that that person shouldn't live there, that's one thing. But for the most part, when you bring in a roommate and you haven't exceeded the capacity of that unit, they cannot evict you because you've brought in a roommate. And it also regulates the initial rent. So these are the 6 reasons that, 16 reasons where you can be, what's considered a good reason to evict somebody. These are the most common. So basically this says they can't just throw you out of your unit for any reason. They've got to have a good cause. Some things that are not included in that, your lease has expired. You do not get evicted because your lease has expired. There's some caveats around that, but basically you are allowed to continue your residency, your tenancy there, even if the lease is expired, it continues typically on a month-to-month basis. The other big one is the building has been sold. A change of ownership does not mean that you have to move. The building is sold with the caveat that the tenants there, their tenancies continue. And so just because the building has been sold or your lease is expired is not a good reason to evict you. And like I said in the last slide, here's the biggest one: not paying rent, you violate your lease, or you're doing something that would be considered a nuisance, a danger to the public or yourself. Now, there are situations where a landlord could say that you're not a legal tenant. They call you a trespasser. They call you, you know, basically a squatter. They call you, you're just considered a guest, whatever it is, that you don't have a legal tenancy there. That's kind of a different situation, different rules apply. So there is a little bit of a caveat there. Often what we get is when somebody's coming into our office or one of our, in our legal aid organizations, our offices, is that the notice that's given or the complaint that's served on the people who live in the unit is not legal. Now, like I said, the law tends to favor landlords. And so one thing that the law also does to give the tenants, you know, presumably kind of a fair chance, is that the court requires very strict adherence, both to the substance of what's in a notice and a complaint and how procedurally that is served. It has to include certain things. It has to be given in a certain way. It has to have certain language in it. It has to have certain attachments to it. All of those things, if they're not done properly, require a different kind of response and presumably can get the case thrown out if they are caught in time and those rights are then acted upon. So it's really good to know if those happen. Now, just as an aside here, I'm going to step back and say there's a whole process that's going on here. I talked before about how a landlord cannot just change the locks and say you are evicted, you're out, too bad for you. That is, that's a very serious thing here. And landlords have almost exclusively stopped doing it because the damages that a tenant is entitled to in that situation are really severe. So landlords have learned that they cannot just evict you. A self-help eviction is what it's called. They're just going to come in and lock you out, throw your stuff on the sidewalk or not, and say that you're evicted. There are very strong penalties for that. So the first thing that they have to do is serve you notice. And that can vary anywhere from 3 days, pay your rent in 3 days, or else you have to leave, to a 60-day notice in other cases, and anything in between. It depends on the type of things that they're claiming. That notice, nothing has happened in the courts. Nothing has happened in terms of anybody else being notified. That's between the landlord and the renter. That's the first step that the landlord needs to take in order to start the legal process. If they went right to court to try to file a complaint and they haven't served a notice, it's a done deal. That gets thrown out. You have to serve the notice first, but the legal action is not started until the complaint is filed. The reason housing is can be so difficult, it's considered a summary proceeding. That is, it's not the classic civil cases like you see, you know, on TV shows or other things that can last for years. Once a complaint is filed, a renter only has 5 days to respond to that complaint. That just means you have to file an answer. It can be a very quick thing to do, but you can be evicted if you do not answer very quickly. So you need to be sure that you get in, get some help, take a look at the situation, and at least go to court to file an answer. All of our courthouses have what's called an access center. They will at least help you get that answer on file so you are still, the case is still live. It's still considered that you have now shown yourself to the court and you can proceed. This still, even though it's a summary procedure, takes several months, if not longer. It can happen faster if you don't respond though, and then you get a default. That's the worst thing that can happen. So hopefully, if one thing you do take away from this is reach out to one of these legal aid organizations and get some advice at the very least on your case. So if the notice and the complaint are legal, then you can respond. The typical response is an answer, okay? But there are other responses. If somebody comes to me and says, here's the notice I was given, and here's the complaint I was given, and I look at that and I say, wait, they missed some things here. They had to tell you some things. They had to attach some forms. I can have a different kind of response to the court. And I can go back and say, look, judge, this person, this landlord, did not follow the rules, and therefore they got to start over. They got to serve a new notice. They've got to serve a new complaint, that sort of thing. So it's very important for anybody, everybody has a right to an attorney in this case, to get to the mayor's office, to get to EDC, and get your complaint in there so you can respond appropriately. Now, that said, almost none of these cases actually go to trial. That is the end result for a few of them, but these are by and large negotiated agreements. If you're behind on your rent, what kind of payment plan do you leave? If that rent or the other things are too bad, maybe you negotiate agreement to move out, but they give you extra time. Maybe they give you some help in moving out. Maybe they waive your back rent. These are almost always negotiated settlement agreements. Landlords are willing to deal. I would hope that that would occur sooner than when we get involved, that there's conversation, and certainly landlords and tenants can come up with negotiated agreements at any point in this process until they have counsel. Then the counsel has to talk. But these can always be negotiated ahead of time. I would always love to see parties coming together to have that conversation first. But if for some reason it can't, then the attorneys can sit down and talk, say, what are your goals? First thing I ask my clients is, what is your goal? Do you want to stay? Do you want to go? How do we make that happen? What's your situation? And then we go with the story. So that is kind of the summary of the whole process. One big thing that happens in San Francisco is what are called owner move-in evictions. Now, these are considered no fault. That is, the tenant didn't do anything wrong, but a person can come in and buy a home to live there with their family. That's allowed. And that is a reason that you can end your tenancy. It does require some certain things, though. It requires a 60-day written notice given to the tenant to say, look, this property, excuse me, has been purchased and the owner intends to live here. And so you will have to go. You are allowed, and in fact required, to receive relocation payments. That varies depending on the city, the county that you're in. Generally is roughly around $10,000 per renter that you have to be paid because you are being forced out for no fault of your own. Certain groups, however, are protected. Seniors, disabled folks, those who are catastrophically ill. That just doesn't mean, you know, you have a chronic condition. It means truly catastrophically ill, that you can't be moved to a detriment of your health. But seniors and disabled folks are protected. Typically, that means they get more money in relocation and more time. So if you're a senior or you're disabled, you get a year to move. So hopefully the owner who's purchased that property understands and has been told there's a senior who lives there. You're going to have to pay them money and you're going to have to give them a year to find a new place. They're not going to be able to move in immediately. If it is a multi-unit building, let's say there are 6 units and the owner lives in one of them, they can choose one other unit to have their family move into, and the rest of the units can stay. If there's a unit that's vacant, they have to use the vacant unit. They can't evict somebody when there's other units that are vacant. Again, there's some caveats to that, but generally they can only use one unit in a building. They can't evict everybody based on owner move-in for 6 different units. And there is a distinction here for those who work in a school system or families with children of any age, that you cannot have somebody move out of the unit so that you can move in during the school year. It has to be done during the summertime to allow those kids to have, you know, or the workers to be able to finish out their school year in the district where they live. So that's one very specific case of when you can get forced out, which is the owner move-in. And the other is the Ellis Act evictions. So this was passed in '85, but updated recently, that allows landlords to go out of the business. Unfortunately, this is a very highly abused act in that it gives a lot of incentive to claim that a landlord wants to go out of the business, get everybody out, and then a year later move new tenants in with a new rate increase, especially if they're long-term tenants who are paying much lower than market rate. They get everybody out, they wait a little while, and then they start renting at market rate. So there is some mechanisms for checking to make sure. For an Ellis Act, there is a moratorium. They are not supposed to rent any units of the building or the home for 5 years. And so that is what they have to do if it's a multi-unit building, if it's a home, if it's ADUs, you know, these accessory dwelling units, ADUs or in-law units, they can't be rented for 5 years. If they want to re-rent them, they have to be offered back to the tenant who was there. Again, they get 1 year if you're disabled or a senior. Other folks get a 120-day notice that they're going to be taking it off the market. This is no longer going to be a rental. Again, there is relocation payments that are required because there's no fault of the renter. The renter hasn't done anything wrong here. So they do get some assistance, again, about $10,000, depending on exactly where and what the size of the unit and all that sort of thing. And there are protected groups. Seniors, disabled, and catastrophically ill cannot be or have to be given more accommodations, more time, more money. And you have to legally remove the property from the housing market. They can't just say, they have to actually register it. And then if they are caught renting it, there are very severe penalties and consequences. Old tenants are supposed to be able to move back in for a comparable rate. And so unfortunately, there's not great coverage in terms of checking to make sure that units stay off the market for those 5 years. Obviously, if you're trying to sell a home and it's empty and you say you can buy this home, but you can't rent it out, it's going to go down in value. And so there are abuses to this system, but they have tightened it up in 2022 to try to minimize that as much as possible. But between owner move-ins and Ellis Act, people will call, I've been Ellised is kind of the term that comes up. And those are two ways you can get moved out for no fault of your own. And then the other ones require just cause, that is good reason. Those 16 reasons you can be evicted if one of those 16 things apply, although there are defenses to those. And we have tenant attorneys like myself who will help you navigate that. So one of the reasons that doing this sort of law in California is so difficult is it's all based on your city, typically, or your county. All of them have their own ordinances and their own rules. So if you're in San Francisco County, it might be slightly different than if you're in Alameda County or Contra Costa County or San Mateo County. The local rules are going to be different. Although they are similar, there will be differences. However, everyone is protected by the state law, which is the California Tenant Protection Act. Everybody's protected by that, regardless of your county or your city. Now, most cities and counties have more restrictions in their local ordinances. You always want to rely on those if you can, because they tend to be more protective of tenants. But the state law is always a fallback if your local ordinance does not serve you well. So buildings that are over 15 years old, that are not covered by your ordinance are covered by the Tenant Protection Act, okay? 2-unit buildings if a landlord has continuously resided full-time since the beginning. So like a duplex where the landlord lives on one side, there is an exemption for those. Or for a single-family home where they're renting out a room, where they're renting out a garage, where they're renting out a basement, those are also exempt. And there's additional exemptions for other things. But the TPA, as we call it, the Tenant Protection Act of 2019, does protect some folks for whom the local ordinance doesn't apply. Again, it's a rental adjustment, so there is caps, not as severe typically as the local ones, but there is a limit to the amount that landlords can raise the rent. And it provides protection for all adult tenants who have been in a home for more than 12 months, or if there's people moving in and out, at least one of the tenants has lived there for 24 months. So there is a fallback if the local ordinances don't apply. There may be protections under the state law. So these are the one things we always wish in hindsight that our clients who come to us would have done. Read your lease. And sometimes they are in small print and they're 15 pages long. There are sections that may not apply, but there's certain things you do have to know. How much is the rent? What's the term of the lease? What are the consequences if you're late on your rent? If there is a late fee, what is it? How long until, actions can be filed? How much notice do you have to give before you want to move out, or the landlord has to give you if they want you to move out? Any and all kinds of details. Are you allowed to have pets? If not, are you allowed to apply for exemptions? In a special case, will they allow it? Get it in writing. And verbal leases, we get a lot of those. People coming in and say, I've lived here for 15 years. We always just had a handshake. I paid them $1,000 a month and I live there, and now they're saying I don't have a lease. It's very hard to enforce terms when there's nothing in writing. So even if you come up with an agreement orally, get it in writing. If you ask for it in writing, it has to be given to you. Your lease has to be given to you. Make sure you've initialed, signed it, that they've initialed and signed it. It protects everybody involved. Now, as I mentioned, just because the ownership of the building, the unit, the house changes, doesn't mean your tenancy ends. But it does mean you need to be aware, because you're not sure what that new owner intentions are. So do be alert if your building is sold, if the home that you're renting is sold, if the unit has been sold. We have a lot of folks that we never see. This is the saddest part of my work, is that a landlord will come to a tenant and say, I don't want you here anymore. Get out in a month. And they just leave. They never come to seek help. They never come to see on what basis they're being asked to leave. If it's harassment, discrimination, they just want them out. They don't want to fix the unit. They want to raise the rent. It doesn't matter. Reach out to somebody and ask, because almost always there is help for you, whether it's rental assistance or a harassing landlord or terms that you didn't agree to. Maybe you used to have parking and now you don't. There's all sorts of situations, and there's almost always ways that we can help you. So don't just leave. I've had many clients who come in and say, they've been just telling me they won't take my rent because they want me to leave. They want me out. Or they told me they're going to turn me into immigration. Or they told me that they're going to start making my life hell. Or they started playing their TV at 5 a.m. on full blast. They're doing all sorts of things. You don't have to leave if you don't want to. There's always ways that we can work and negotiate solutions to these things. So please learn your rights, ask for help, reach out. This, of course, is the main place, because they are as I said, the lead partner for the Tenant Right to Counsel, TRC, Tenant Right to Counsel project. They take cases themselves and they farm them out to the other 6 or 8 of us organizations. We all have specialties, and so you're going to be matched with an organization if at all possible. If you're not an English speaker, I work for an API organization. We also handle a lot of Hispanic folks who don't speak English. There's other agencies who also have language capabilities. We have organizations that work just with seniors. We have organizations that work just with AIDS clients. We have organizations that work just with disabled folks. The Homeless Advocacy Project works with folks who have particularly hard mental and behavioral health problems. There's always an agency that can help you. So please do reach out. If you start at EDC, they have hours of operation where you can walk in, and they also have call in. And if they can't help you, they farm you out to somebody else who does have capacity. Even if you're one of the small set of folks who isn't entitled to full scope, that is an attorney who can take it all the way through trial, we can help you at least answer the complaint that's against you, give you some advice and some counsel, reach out to your landlord, do some initial negotiation on your behalf, help you come up with an agreement that will allow you to either have time to move or a payment plan to stay. All sorts of options are out there on the table. I help my clients get benefits. I help my clients get unemployment. I help them get rental assistance. I help them get in-home services, whatever it is that can help them solve the problem that got them to this point, to make sure that they can stay housed successfully and get the services they need to be able to continue to live there. Okay, and as I mentioned, there's other places that you can reach out to help for help. The rent board is great if you have issues about habitability, you don't have hot water. A lot of folks don't have heat. These things are required by your landlord to give you. You can file a petition there. They can force your landlord to remediate the problem. They can also even do some retroactive payments to force your landlord to pay you a portion of your rent back that you did not have those services for. They're great. They take these things very seriously. They're a great resource as well. You can see there's housing rights committees for certain areas where you can drop in and hear about your rights as well. And of course, the Department of Building Inspection, they come out and do inspections of units to make sure everything is up to code. And again, force the landlord to be able to resolve these problems, repair problems, fix things, bring things up to code that might not be. So that is the end of my presentation. I know I've thrown a lot of information at you very quickly. Please do put questions in the chat. We'll deal with those at the end. We want to make sure we have enough time. I'm happy to hang out for as long as it takes. If there's, you know, either rabbit holes that you want to come down, or if there's, you know, just more clarification that you need. It's been my pleasure to present this for you. I'm going to turn this back over to Aristos.
Thank you very much, Maria. So what I will say regarding this slide is that if you have been displaced from your tenancy due to an eviction action, you may qualify for a lottery preference in our city's affordable housing program. That being said, please explore the link attached to this slide if you have further questions about the qualifications and details of this resource. I would like to once again say that everyone here is welcome to join us on Saturday morning at the Housing Expo. The Resource Fair and Help Center will be useful for anyone exploring new housing, other possibilities, and simply looking for help with their current situations. And thank you all for your time as we appreciate your attendance. Now we would like to open the floor to any questions that the audience may have. And please feel free to reach out to Home Ownership SF if you have any further inquiries. We also ask that everyone here fill out the survey before exiting. We would very much appreciate that. But once again, thank you all for your time. Thank you, Maria, for an eloquent presentation on a lot of material. Working in this city, in this sector, is it brings its own challenges, like she said, as compared to other venues. And it's important more than anything to understand that this city has plenty of resources that can be easily accessed by asking for help. And that's the thing that I think I would like to stress, is that reaching out to our coalition of agencies, it doesn't hurt to ask. And I think that's just the first step in getting positive resolutions. So thank you all for your time.
I'm
Let's see.
happy to jump in here just to address a couple of the things in the chat that will take me probably far too long to type a response. I do have a question here. How long do you have to change your mind if you accept a buyout from your landlord? Typically, those are binding as soon as you sign them, but often you have 3 to 5 days to be able to opt out. It depends on the city and the way that the buyout is crafted. I've had ones that I have crafted that have said this person can back out in a week. But typically speaking, in Alameda County, for example, that's actually written into the code, how much time you have that you can change your mind after signing that buyout agreement. But if you've written one and signed it with no provision, then you may not be able to change your mind. And so it kind of does depend. It does not, the follow-up question, does accepting a buyout as a tenant harm your ability to get low-income housing? No, it does not. The one caveat to that is a buyout agreement, if you're actually getting cash, can count as income. And so in that sense, it may make you ineligible if your income is too high for that year. However, if the buyout has to do more with time or with rental waiver, then that's not going to count against you. So in the sense that it is income, it could be a problem. But unless it takes you over the limitations, depending on the particular low-income housing that you're looking for, what your income is, it can impact that. But generally speaking, a judgment on your record is going to hurt you much more than any buyout. And so you'll want to do pretty much everything you can to avoid that. And just because you have been sued in eviction housing court does not mean you have a judgment. However, there is a pretty active landlord association and blacklists that exist out there. And if your name shows up, sometimes you will get denied housing. It's illegal and it's unfair, and we're doing everything we can to shut those down. Evictions are masked in San Francisco if they are under a certain amount. And I always write into my agreements to make sure that they are masked going forward. And so they should not impact your ability to get housing in the future. But these blacklists are out of our purview, and we often don't have much ability to impact that. But you do have a right when you're applying for housing to see the credit review, to see where they're getting your information. Because of course, sometimes these complaints get filed for spurious reasons. Somebody just wants to force you to do something or get you out. And then that can come up on some sort of listserv, but you've had no judgment. And in fact, you could go to trial and win, and you still get on these lists. But they are supposed to be masked in most of the Bay Area, most of the cities. And you can always insist that they are masked. Sometimes if they take longer to resolve, they'll be made public. And I've filed requests with the court to mask a case so that my clients can continue to look for housing. They have a move out agreement, they're going to go, but if it takes too long, this may become public and then suddenly they can't find any place to move. So always ask about that, and always make sure that you're sort of aware, of that purview. I hope I answered that question. Feel free to jump in if I didn't. Okay, I think. Okay, here is another one. If I accept a buyout to move out and live with roommates, but they are short-term and I'm the long-term leaseholder master tenant, do they receive an equal amount of the buyout? No, you get what you negotiate. And so in this case, you are the master tenant, and I'm not going to ever give advice that would cause somebody else to be evicted. So I'm not going to speak to what's going on between you and your subtenants. But hopefully, if you are all working together, you come up with an agreement that is fair. That doesn't necessarily mean equal. A master tenant or someone who's been there longer will often get more money, but hopefully the landlord, there's only value to the landlord in this situation if all the tenants move out. So you may want to have a whole agreement where master tenant gets X amount, subtenant gets Y, subtenant number 2 gets Z. Okay, they can be different amounts. They can negotiate. Everybody might have a different reason. This is why one attorney cannot represent all of you, because you might have different interests here, different amounts. Somebody might want to stay versus somebody might want to leave. So you'll need different representation in that case, but they don't necessarily receive equal amounts. If you're negotiating directly with your landlord, you can negotiate different amounts. As a master tenant with the subtenants are short-term, and if their time is up, they might not get anything and they might be quite happy to go, but it's all a matter of how you craft that agreement. Okay. Okay, do tenants housed within a program have any rights not to be abused by housemates? In Baker's co-op tried to go to the court system in APS, but no one wanted to step in and couldn't point me to an organization who could. Obviously, if you're being assaulted by a housemate, that's never going to be legal. So you do have a right not to be abused by your housemates. Unfortunately, the options are not great here. And if you, this is kind of a complicated answer. So it depends on the lease, who's listed on the lease. If you're all on the lease, it's going to be more difficult. You do, if you've been assaulted by a housemate, you do have also what's called VAWA protections, the Violence Against Women's Act. You can't be forced out because you've been assaulted by a housemate, but of course they can be if there was a criminal complaint, if there's a police report, if this person has left, there's also restraining orders that you can get against housemates and force them to be out if you are the victim. So yes, you have a right not to be abused. It's a little tricky when you're in a co-op because there's separate language around the co-op. I would refer you to Bay Area Legal Aid. They have some specialty in this area, and each county has their own Bay Area Legal Aid office. So depending if you're in San Francisco, you'll want to go to the SF Bay Area Legal Aid office. APS is only going to help if it's a senior. If you're a senior or your housemate is a senior, they will come in and do an assessment, but they don't provide direct services, but they can certainly help with your efforts to have somebody removed if they're abusive. So I would push back on that. Restraining order you can apply for yourself. You will have to go to a hearing. They can order one on an emergency basis if it's an emergency, but you will have to go to a hearing, and your abuser has a right to be heard at that hearing as well. And so that would be one option. If you're not safe, please find a place to go. Your safety is of paramount importance. So please be in a safe place as quickly as you can, and then work on getting back to your unit. But you definitely do have protections, either again with the Violence Against Women's Act, and that you don't have to be a woman to take advantage of those, just as a caveat there. Violence Against People Act it'd be better. So if one of you is a senior APS, I would insist that they come at least do an evaluation and they can make recommendations. You can also call, I hesitate to advise anybody to actually call the police because I'm an abolitionist, but you know, there are some alternative to police actions, some social workers, some other agencies that can reach out and help you, but you can always call the police and have them file a report, so you have that history, which will also help you if you need to get a restraining order. That's about all I can tell you in this forum. I would say if you have further questions, go to EDC and see if they can refer you to some other agencies based on your particular situation. Yes, there are many, many unfair things in the housing market in San Francisco. A lot of landlords have a large financial or other kinds of incentives to get people out of their housing units, and there's a lot of abuse. I'm sorry to say, I have had some dealings with some very good landlords who really went to the court system only as a last resort because they were concerned for the safety of their tenants. So there are good ones out there too. But there's a lot of bullying and harassment and discrimination going on. All I can advise is get these agreements in writing, make sure you know what you're getting into, make sure what the consequences of your action, keep lots of records, and keep looking for a place where you can be well and safe. I'm out of town, can I answer? Okay, there's another question here about rent payments. This depends a little bit on your lease. Hopefully your lease allows you to pay in many different forums. So they cannot require you to pay cash. They cannot require you to use their portal, but those of course are options. If you usually pay by check on the first day of the month, but then you're out of town, you can do a direct deposit through your bank. You can also work out an agreement with your landlord that in the event, you can even just have a little amendment in writing. In the event I'm out of town, I have until the 10th to pay, or make sure you put that check, give it to somebody who can mail it to you, something like that. You cannot force them to give you a bank account number. But I would say if you have a good relationship with your landlord, just sit down and write a quick paragraph and both of you sign it. In the event I'm out of town, this is what happens. Or look at your lease. Maybe you have a 5-day grace period. Maybe you have a 10-day grace period. You can alter that too. Maybe you start, paying, as long as something's paid by the 15th, between the 1st and the 15th. It all depends on your relationship with your landlord. Anything you can negotiate in that regard, and the more directly you can do it, the more likely you are to be successful. And so any of that can happen. If they're insisting that the only thing that they do is take checks, then, all I can say is, post it, put it in the mail, and post it beforehand. And even if it arrives, it's considered paid when you send it. So I'm not sure if that's totally answered your question. Feel free to follow up if there's something further. All right.
Well, I would like to say that we are rounding out here now that it is almost 8 p.m. See another comment here. Let me see. From Lydia. If my sister is listed as a master tenant but moved out a few years ago, I inform you, even though he has listed me by name on the rent increase. Quite an odd scenario. Maria, what are your thoughts on this one?
Yeah,
denial right here.
Right. I'm assuming here that you don't have a new lease without your sister's name. But if you have informed them that you're there, they're claiming you don't have a lease, even though he's listed me by name on rent increase documents, and of course has been accepting my rent payment. So I'm not sure what they're trying to do there, if they're trying to get you to move out. The acceptance of rent is itself a form of a proof of tenancy. And so if they've been doing that for a couple of years, he would have to have what's called just cause, one of those good reasons, or the owner move-in or the Ellis Act in order to evict you. And so if he gives you a notice, I'm not sure on what basis, if he's alleging you breached the lease, you don't have a lease. This might be one of those situations that I mentioned in one of the earlier slides, where if he's claiming you're not a tenant, and because you don't have a lease, that's a little different situation. They might file what's called a forcible detainer against you instead of an unlawful detainer, saying you're there without permission. And so, you know, that's a different situation. You can respond differently. You still have to file an answer, but it would be pretty clear in a case. They wouldn't ever probably take this to court, because if they have been accepting your rent and you have your name on their documents, they're not going to get anywhere with that. They would lose at trial. And so it's pretty clearly a case where they're not going to, you know, it's a matter of trying to figure out what is their goal. Are they trying to evict you and why? And then how do you address that? I believe you do have, you have become a master tenant. You've been there over 24 months from the sound of it. So you have pretty strong protections in that case. I would, if you have the relationship with your landlord to have that discussion, you can. Otherwise, reach out to one of the legal aid organizations. And so if something does happen, you know, you can't just let it go, right? He will serve you with a notice and then a complaint, and then you can just say, great, I'll see you in court, because you don't really have a case. But yeah, keep the lines of communication open as best you can. It's always my first line is, you know, just keep talking. Things can be resolved. You're quite welcome.
Well, everybody, if you haven't had the chance yet, please try to fill out the survey. Again, thank you for your time. Looking forward to Saturday. So if anyone, is looking to go there, we'll be happy to see you. Definitely connect you with whatever resources, and just get a pulse on our organizations and how we can support you in these situations. And also, it's always great to be proactive in your tenant-landlord relationship. So fostering transparent communication, or as Maria said, being aware of your landlord's intentions goes a long way in terms of your housing security. So again, thank you all for your time. Very much looking forward to just being present on Saturday. And I think at this stage, we'll look to wrap up the presentation, and wish you all a good evening.
Thanks to everybody. Good luck. Pleasure being with you. I will hang out here for just a few more minutes. If there is somebody wants to unmute or somehow put a question in the chat, I'm happy to help.
Hello.
Hi.
Hi. I was the one that sent the question in about accepting how much time you had to change your mind about a buyout.
Yes.
So I was just looked it up in San Francisco. And so I don't know if it's outdated, but it says that you'd have 45 days from the time you sign. So is that still?
I guess I would have to see what it is you're looking at. Do you have an ordinance or a code that you're looking at?
I'm just at sf.gov, and I just under buyout agreements.
Okay, I am not aware that's a 45-day. Let me see if I can. I know in Alameda County it's much shorter than that. So let me see here.
Okay. I was just wondering, has it changed, or is this correct, or?
Okay, before engaging. So
Under timing.
Timing may be executed no sooner than 30 days after they. Okay. Did your landlord give you a pre-buyout disclosure?
Yes.
Okay. In writing contains a statement the tenant may cancel the agreement anytime after all parties have signed. Wow, 45 days, that's great. Can cancel after it was signed by informing the landlord in writing that the tenant has canceled the agreement, or words. Yep, that looks pretty cut and dried to me. Let me take a quick look at the rent ordinance section and see if there's any caveats to that we need to be aware of. I had not run into that before. I haven't really had
Oh,
so evicting, buyout agreement, disclosure, right not to enter. I choose to call attorney, buyout, may rescind it. Does the agreement have that language in it?
actually, we're like negotiating.
Okay.
So we've just settled on an amount in a move
Okay.
out time, but so we haven't had the
Right.
contract written out yet.
Right, because it does say that the landlord shall provide a written disclosure on a form developed and authorized by the rent board, and it has to include that you have 45 days. Statement about rights, notification, and then you have to file it with the rent board, and has to be in writing, and has to, okay, all sorts of 14-point type. Yeah, we all know how important that is. Have the right to rescind for up to and including 45 days, as long as you do so in writing, hand deliver, email, or place it to the landlord. And then it's got to be filed after that with the rent board. Yep, I think you're good to go. Yeah, that seems legit. I hadn't run into that before, so I'm glad that you brought it up.
Okay.
Yeah, typically those are, I mean, that's actually pretty generous considering what I've seen. Like I said, in Alameda County, I think it's like 3 to 5 days. Usually
wow.
my agreements, I'll try to put in a caveat there that they can change their mind, although it depends on what the landlord is giving up. So most of my cases, I have clients who are really far behind in their rent, and they don't want to give that person a chance to change their mind,
yeah.
right? And so there's not a lot of leverage there to argue for that. I think any contract, you have 48 hours, to rescind any contract. Now,
Right.
in my case, my clients are gaining typically more than they're losing in these situations. Even if they have to move into housing, they're often getting, 6-figure amounts of debt relieved. And so they're not likely to walk away from that. But there is one time that I wish my clients would have changed their mind. They found out they couldn't abide by the deal. But yes, that looks like you're right. So yes, be sure that's in the language. In case you do need to change your mind, which it looks like it has to be according to the rent board. So good luck. I hope your negotiations are successful.
Well, thank you. Yeah, well, so we're the reason why that was important is because we're having a hard time because we're low income finding a home.
Yes,
And
that is a huge problem. You can agree to
so if
leave
we
all
don't-
you want, but if you don't have a place to go,
Yeah,
you're screwed. It's a problem.
So if by the time that buyout date arrives, if we have that move out date, we haven't found anything, and it's not. We still have time, at 45 days.
Right.
To change our mind. Yeah,
exactly. And you might even want to put in, see if you can negotiate some other terms, in terms of if we don't find a place, we can stay, but we pay this amount for each week we stay, or some other fallback measures. So that, you're not suddenly in a hotel or something really, unaffordable. So, you may or may not get it, but it doesn't hurt to ask.
Right. Okay. Well, I sure appreciate your time. Thank you so much.
You're very welcome.
Bye-bye.
Bye-bye. Okay, Lydia, are you still here?
Or I don't know if you're available for a follow-up. I was the one who asked the question about being in a Bigger's Place co-op.
Yes.
Yeah, and I tried to do a restraining order, or at first I tried to do a police report, and they refused to do a report. They just said do a restraining order, but it got denied. And the reason, the one sentence says, oh, this needs to be taken up by the case managers. So even though I put in copies of the grievances I sent to the city and, the emails to the case managers, and then I went to APS and yeah, they didn't really, no one really wanted to step in, they kept on punting it back to Baker's Place to
Yeah.
handle it.
These are
So I
hard
don't know.
situations and nobody wants to be in the middle. So what is your situation right now? Are you still living with this person?
No, I mean, it went on for like 11 months. Eventually I like broke down and went to treatment and just moved. But there wasn't any single rooms. I had to get a shared room. I'm still not with a roommate right now, but potentially I could get a roommate. And I'm just wondering if this happens again, what are my options? What can I do?
Well, co-ops and HOAs and those sorts of situations are really their own beast. So unfortunately, I'm not able to give you any firm advice except to make sure that whatever co-op or HOA agreements that you have handle situations like this. If there's nothing in that agreement, there needs to be. And there are co-op attorneys.
There was like, you have to sign an agreement to get in the program, and she was definitely violating a lot. You're supposed to do weekly house meetings, you're supposed to do weekly one-on-ones and stuff, and then it also says you're not supposed to abuse people, but
And what was the grievance procedure if somebody had a complaint about that? Was there something in the agreement that says this is what you have to do?
I mean, I went to the grievance office and they sided with me and said she needed to move. But when I had a final talk with the supervisor, they're like, oh, it's too expensive. You don't have a good case. Like it was like not an option for them to move her at all.
Yeah, unfortunately, all I can say is you got to fight back on it. There's really not much else. They're only as good as the paper they're written on. And unfortunately, that puts all the burden on you, the victim, which is not appropriate. And so I'm not sure what else to advise you. There should be very strict guidelines in your CCPs or, in your co-op agreements that say what exactly is the procedure. Somebody doesn't just get to decide that somebody gets to stay and somebody else has to leave. There needs to be a process to that. And there are ways that it doesn't have to be expensive. It's going to cost money to get somebody to move out, but there are mediators even that can mediate these situations, or arbitrators. Besides, filing a complaint. Filing a complaint and going to trial is certainly not cheap, but like I said, most of these are negotiated, and so you may need to advocate that, look, your safety is in jeopardy, and I would say if you're out of that situation now, that doesn't help you for the past, but just to make sure there are very strong protections any place you do end up, so you don't have to go through that again. I'm so sorry that was your experience. That's not how it should go.
Yeah, I'm just wondering, so you're saying, I mean, maybe try to go through mediation services to try to
Yeah, most courts have an alternative dispute unit that helps with these sorts of things. Even in eviction proceedings, you're required to do a settlement conference between the parties to try to work out an agreement. The courts are so backlogged, they really want these things to be negotiated and settled. It kind of works out better for everybody if the parties involved are involved in that. I was a mediator before I actually became a lawyer. I'm a big proponent of that process, so everybody can get heard, see what the goals are. Maybe it doesn't even mean this person leaving. Maybe it means they're in treatment. Maybe it needs, there's some other options as far as people being in different units or no contact rules. Any of that can be negotiated. And unfortunately, it means, they even have advocate programs. So if you can get a victim's advocate to also help you in that negotiation, that can be helpful too. So there's lots of ways. I mean, them saying, boy, it's too expensive to move her out, that's a cop-out. You just got to say, sorry, that's not a legitimate answer. Somebody doesn't have to go through a breakdown before something gets resolved. And this person needs help.
I mean,
so
because I was
let's get 'em
going
help.
through like 11 months and I just eventually, like, I just had no leverage,
Right.
so.
Right. Yeah, unfortunately, that's the risk of some of these folks. So yeah, at this point, that's about all I can tell you. I'm sorry I
Okay.
can't do more. Yeah,
Okay. Well, thanks for, talking with me about it. Yeah, thanks.
you're quite welcome. You're quite welcome. Okay, Lydia, You don't have a lease in your name. You just qualified for Section 8. Owner says he isn't going to go with HUD. One of the reasons he said was because I didn't have a lease, and gave a few other random reasons like not getting along and supposed damage to the unit. I would like to stay in the unit and have the housing authority pay. All right, I need some more information here. Lydia, are you still on?
I'm still here, yeah.
Okay.
Mhm.
Are you wanting to move to a new unit, or you're wanting to stay in the new unit you have?
Stay in the unit I have,
Okay, and they're saying they won't take your voucher?
correct.
Okay, they can't do that.
Mhm.
Actually, there's just been some new law about that coming into force in the last 6 months. They are not allowed, that's called discrimination based on source of income, and they're not
Mhm.
allowed to turn that down. Now, it's pretty rare because for most landlords, Unit 8 is like cha-ching, right? They're paying. They don't have to worry about you paying. The government's going to pay.
Right.
So they don't
Yeah.
usually argue that, but they don't get to say, we're not going to go with HUD. They have to take your income from any valid source, and HUD is one of them. And so you can, reach out for some assistance, certainly, but going in and saying, look, you guys don't have a choice. There's legislation that prevents you from discrimination based on where my housing voucher, that I have a housing voucher even. It's like saying, boy, you're an auto mechanic, so we won't rent to you because you're not a lawyer. Same thing. You can't do that. And
I
so
think that's why they started to mention, he sent me this random email of like you said, they trying to make some like, oh, you guys, like, there's a, you know, like a cabinet that's broken or something like
Yeah,
that, like
yeah.
like a list of grievances. And I'm like,
Right,
really?
right. And they're going to
You
say suddenly
really?
now you've broken your lease, or there's something else. No, just
Right.
don't take
Yeah.
it from them. Reach out to my agency or to EDC,
Uh-huh.
and just tell them cease and desist. This is harassment and I won't be doing it. If I'll let you know what's broken and you can come fix it.
Yeah.
And if they say, well, you caused it, you can say, well, okay, here's my proof, whatever it is. But
Mhm.
saying they're not going to go with HUD, you just say, look, that's discrimination and you're not allowed to do that. Here's my documents. And reach out if they're not taking them. Bay
Mhm.
Area.
Yeah, I mean, I've given him the documents. He said he's not going to fill them out. So I'm
Yeah,
trying
well, then
to.
he doesn't get paid, does he? But it's not your fault, and so he loses rent.
Well, right, but I am paying rent. I mean, I am paying my rent now.
You're paying your
the
part,
thing.
but HUD isn't going to pay until he fills them out, and you can just
Right,
let
exactly.
them
I
know.
mean, I'm paying full rent right now because this is a
Oh,
new, I mean, this is a new voucher. So
okay, okay.
I'm paying full rent now. So I want them, they have to come in and do
Yes.
a like an assessment
An
of the building,
inspection,
and
exactly.
inspection, things like that.
Yeah.
He says, oh, it's not going to pass. So I don't, I'm like, I
Oh,
don't think that there's anything
that's his
huge
problem.
wrong with it.
Yeah, of course he doesn't want to do it. That means he's not up to snuff. Just stick by your rights. Tell him he cannot discriminate against you. You're doing it. You keep paying whatever portion HUD doesn't pay as soon as that gets approved. And then you just say, look, if you don't take their rent, you might lose out, because he can't then sue you for non-payment. Because he can't
Should I
discriminate.
submit the paperwork to HUD without his signature?
I would talk to HUD, call up your
Okay.
caseworker and say, look, he's
Mhm.
not going along with it. What should I do next?
Mhm.
Maybe they'll reach out to him. You might want to tell him to reach out to an attorney because what he's doing is illegal.
Mhm.
You're going to pursue it. Don't, he's trying to push you around. He's trying to get away with this. So don't let
Yeah.
him. Because he'll do it to the next one. And I'm here for you if you need assistance and support on that. I can, send you the right things, but they need to talk to their attorney to realize they can't do this. It's illegal. You do what you can, talk to the housing authority, and just keep moving forward as though he's going along with it. Keep sending him emails. Those are writings that counts, or letters, whatever it is, to document what you're doing and the notice that you're giving him. You want to have records of all of that if it comes to a head. But
Mhm.
probably once you stand up for yourself and don't let him get away with it, he will come into line.
Maria, this
Okay.
is a great resource you shared with Lydia. And thank you, Lydia, for sharing your situation.
Mhm.
Maria, is it possible if you could put in your information on the chat so Lydia may be able to contact you, because it sounds like there may be a little bit more information that she would want to discuss, if that's
Sure.
okay with you.
Yep.
Unfortunately, it's about 8:20 right now, and I
Oh
thank you
my.
so much for everybody who's on the chat. If in any case you do have any questions, as we mentioned, as Arisa had mentioned earlier, we would love to see you again at our in person at our expo at Leola Havard. I've put in the chat the address earlier, as well as the information about our additional workshops for tomorrow. Thank you so much to our presenters. Maria and Aristos, you've been great. We've had our interpreters. If anything, please let us know if you need anything. You could also contact us here at Homeownership SF for those who are in the chat or in the Zoom room. Thank you so much, everybody. Have a nice evening.